Thank you very much for the invitation to Professor De Paulo and to everyone else. Thank you very much for sitting through this. It's been a long afternoon and unfortunately I have the worst position because I'm the only thing that stands between you and a break. So you'll have to bear with me. I will try and keep it short. I've been told I have about 10 to 15 minutes, and if you have any questions at the end of it, of course, you can always ask me in the break. I'm going to talk about another aspect than what we've been hearing about today, which is the legal side of things. What we've heard about mostly today is about the practice and the development of mediation, conciliation, alternative dispute resolution. I'm in the business of looking at how law impedes the development of business transactions, particularly international business transactions. I work for the International Trade Law Secretariat, which is part of the United Nations Commission on International Trade Law in Vienna, Austria. Our office is actually based in New York, but we work in Vienna. So just to start off, I'll start with telling you a little bit about what I'll be talking about, which will basically be about the United Nations Commission on International Trade Law Model Law on International Commercial Conciliation. It's an instrument that we've developed over a period of nearly 2 years in discussions with our working group on arbitration, which is an intergovernmental organisation which basically looks at dispute resolution issues. In the context of conciliation, there was a growing disenchantment with the traditional methods of dispute resolution, such as litigation. And I've just been told I knew this would happen, I've been told to slow down. I do feel sorry for them actually. They have to deal with my Australian accent as well as the speed which I speak. So I'll try and remember to slow down. As I said earlier, there's been a disenchantment with traditional methods and there's been a growing development of different methods of dispute resolution. And conciliation fitted into that disenchantment because it provided a much easier and less complex and less adversarial method for resolving disputes. We've already heard that conciliation definitely provides a tool for preserving an ongoing commercial relationship, because obviously if you go to court or if you go to arbitration, parties do tend to be in a very adversarial position, and preservation of the commercial relationship is pretty unlikely, particularly when it involves litigation and all the costs and the bitterness that goes with that. Conciliation also provides parties with a lot more freedom to tailor their dispute to suit the particular dispute and to suit their outcome. Before we had the model law on international commercial conciliation, we had what's known as the UNCITRAL conciliation rules. This is just one of many contractual rules that parties can use to resolve disputes by conciliation. They were adopted in 1980, and as I said, they have a contractual rather than a legislative status. And they cover all aspects of conciliation, from appointment of the conciliator right through to the settlement of a dispute through conciliation. They offer an internationally harmonised set of rules for resolving international commercial disputes, and they've been quite successful, used both in investor-state dispute resolution and in private commercial disputes, as well as in institutional or ad hoc, which are unadministered conciliations. But there are limitations to the UNCITRAL conciliation rules, and that main limitation comes from the fact that they are contractual and not statutory, which means that they can be overridden by contrary mandatory laws, and obviously parties will sometimes not always respect the outcome of a conciliation because there's a lack of enforcement methods. So this makes it fairly clear why UNCITRAL decided to start working on a model law on conciliation. There was no uniformity in laws, and the laws that did exist were a patchwork. They were contained in different pieces of legislation. So if a party who was in dispute with another party from another country, for example, wanted to know what law would affect that conciliation, it was hard for them to work that out. And this obviously affects confidence in conciliation as a method for resolving disputes. Some other issues that couldn't be resolved by contractual rules were what were the role of courts in a conciliation, the admissibility of evidence in a conciliation in later proceedings, such as in arbitration or litigation, when a conciliation did not succeed, and also the enforceability of a settlement agreement. All of these things can't really be resolved without some legislative support. And it was thought that the model law would promote harmonisation, certainty, and foster confidence in conciliation. So just briefly, I said to you already that the model law was developed by the Working Group on Arbitration. This working group meets twice yearly for a week, and the Secretariat, which I'm part of, prepares papers. It's usually made up of delegates who represent expertise from the different countries who are member states, as well as observer states and intergovernmental organisations. After a series of several meetings, the model law was adopted in June 2002. Some of the principal concerns I've already mentioned are what was the role of a conciliator in subsequent proceedings, what's the process for appointing a conciliator, other statements or any other evidence made in conciliation inadmissible in subsequent proceedings, and how can settlement agreements be enforced.